welcome back on air with Studio Legale in Balestra. Today we are speaking about private international law, and because this is a global matter, here's the English version of the original Italian episode, and if you wish to see the Italian version, please click the link below or go to the Italian channel on the website or on YouTube. First of all, let's see briefly what does private international law, which can also be abbreviated in PIL, mean. This subject has the function of telling us what are the applicable rules in all the cases of private law in which the counterparties are from different countries, or there are otherwise some elements that go beyond the normal relationship within a particular state. Practically, it helps us every time we experience some transnationality element. In this case, the PIL norms have a double function. On the one hand, they show us what is the substantive law applicable to a case, and thus rules and case law which apply. And secondly, to determine which is the competent court to hear the case, and so which court has jurisdiction over the same case. In Italy, the discipline is regulated in a rather complete and organic way by Law 218, year is 1995. Even though, of course, depending on the time of matter, we must also coordinate with the increasing number of the European Union regulations or by international conventions. In fact, we should always keep in mind that PIL standards tend to adjust all the private transnational matter, and therefore they cannot be found in a single text, since it goes, for example, from succession matters to contracts. Today's deepening concerns the transnational contracts, and therefore we will see first which is the applicable law, and then what is the competent court. Regarding the applicable law, the Law 218 confirms the validity of the Rome Convention of 1980, which consists of 33 articles and was signed in time substantially by all the EU member states and beyond. The Convention elects the primary rule of the will of parties, which can be expressed inside the contract when is specifically indicated what law is applicable, or tacit when the choice, even if not indicated, can be reasonably be deduced from the contract. If this criterion is not applicable, there are quite specific subsidiary criteria, such as, for example, for credits, the law applied in the debtor's country. For contracts that concern real estate, the law of the country where the property is located, and for contracts that concern consumers or workers, there is a particularity because the choice cannot in any event deprive these individuals of particular protections provided for by the legislation of residence. However, with regard to relations between individuals that are inside the EU, the Convention has been replaced by Regulation 593 in 2008, which confirms the criterion of counterparties' choice, and now also includes the dépeçage technique, which means that the various components of the contract may be governed by different laws. Of course, there are a lot of other criteria that we cannot go deep into for time's problem, but I think it's worth to briefly mention the e-commerce phenomenon, in which the will of the parties criterion cannot be applied if one of the counterparties is a consumer, and in that case the regulation prescribes the applicability of the law of the place of residence of the consumer. Finally, talking about jurisdiction, according to the Italian law 218, there are three alternative criteria for there to be jurisdiction of the Italian courts. One, the defendant's home in Italy. Two, the defendant's residence in Italy. Three, for legal entities, the presence of a representative authorized in Italy. Even here, however, if the defendant is domiciled in a UE member state, we have to apply another regulation, which is the 44/2001, which provides the jurisdiction of the place where the obligation was to be performed. Of course, we are still talking about contractual matters, and there are also some particularities. For example, for branches and agencies, the headquarters, and for the trust, the place of domicile of the trust. Thank you for watching, and I hope to see you for the next video. If you have any requests, please visit our English website. Goodbye.